So basically I'm going to be talking about two firms and the enforcement of intellectual property rights in very recent times and currently. That is Monsanto Agricultural Biotechnology Corporation, and in the 1920s a firm called Stark Brothers here in the United States. It's one of the largest nurseries then in this country. Many of you are probably, no doubt, familiar with Monsanto's program in genetically modified foods and the reactions to it. That is, modified plants, I mean. Monsanto, to remind you, is a multinational firm based in, it's an agricultural biotechnology company that's based in St. Louis, Missouri. It has, last year or the year before, more than $11 billion in annual sales and more than $2 billion in profits. It aims to presents itself in a way that you see up here as a benign and benignly purposeful, socially purposeful actor in the world scene of food and biotechnology, agriculture and food. It aims to feed more people while sustaining the planet and reduce the cost of food. How does it seek to do this? Where do I point this? Anywhere? Okay. How does it seek to do this? Well, a major way it proposes to do this, and it says it's doing it, is by the genetic engineering of plants. It's best known for the crops that are trademarked and patented, known as the Roundup Ready plants. They include such crops as soybeans, canola, cotton, and one or two others. These are plants that are genetically engineered to be resistant to the spraying of Monsanto's own Roundup Ready herbicide or pesticide. Monsanto, by the way, was a giant chemical corporation before it became transformed itself into an agricultural biotechnology corporation. Now, this process of the encouragement of farmers to use Roundup Ready seeds for these different crops has encountered considerable resistance, beginning here in Europe, spreading to the United States, and now is manifest around the world. The principal objections in general are that these seeds will pollute the environment, driving out other seeds that are natural, that it jeopardizes public health by producing edible crops that may provoke allergic reactions of one kind or another in those who consume them, and in principle that it is the genetic modification of plants constitutes an unholy interference with nature to produce what are commonly called frankenfoods, after, of course, Frankenstein. And here is just, I mean, there are many cartoon comments as well as articles about this, but here you see an organ grinder who is an ear of corn, or which is an ear of corn, whatever you want, with a little monkey asking for money to combat the Monsanto juggernaut. So, these are the general objections to the Monsanto juggernaut. But there's also a special kind of anger arising from within the agricultural community, and it has to do with Monsanto's intellectual property in its genetically engineered Roundup Ready crops. Roundup Ready crops are patented, and Monsanto has insisted on the aggressive protection of its patents, that is, its IP. It now has, by the way, including these crops, but not limited to these crops, 674 agricultural biotechnology patents. Why the fury among farmers? Well, a lot of farmers like Monsanto's Roundup Ready crops because it saves them, for example, from having to till the soil before they plant the crops. The purpose of the tilling being to dig up all the weeds, etc., that might grow up then and threaten the crops. So it's easier, more efficient for them, and in some way, and it's cheaper. They wouldn't do it if they wouldn't plant these seeds if it weren't cheaper for them. So why the fury among farmers? Well, the reason is that not all farmers embrace Monsanto's seeds, Roundup Ready seeds, and Monsanto has called a number of them to account for growing, say Roundup Ready canola from seeds that, for example, the wind or birds have taken onto their fields, where they have taken root. Moreover, Monsanto has deployed an army of investigators to search out such alleged violators. The investigators have used strong-arm tactics to gain information and threats of endless lawsuits and financial damages to persuade the alleged violators to cease and desist. And I'll return to that later on in these remarks. By and large, Monsanto has succeeded very well in protecting its IP. Why has this been the case? Well, it's tempting to say that the reason is fundamentally because Monsanto is a huge and powerful multinational corporation. Well, to be sure, that's part of the reason, but I don't think it's adequate simply to say that Monsanto is big and powerful, therefore it wins. I think we need to go further and ask what specifically has enabled it to deploy its power in this successful way in the protection of its agricultural intellectual property. So to answer that question, I want to establish a historical backdrop against which Monsanto can be brought out in bold relief, which brings me back to Stark Brothers and basically the period of the 1890s through the 1920s in the United States. Okay, so, so Stark Brothers, Nurseries and Orchards, was established in Louisiana, Missouri in 1816 or 18, depending on which account you read. It's on the Mississippi River, just across from Illinois. The town is tiny. Its current population is about 3,300 people. But Stark is one of the oldest and was long the largest nursery in the U.S. In the 1920s and 30s, Stark propagated and sold hundreds of thousands of golden, delicious apple seedlings. I'm going to come back to that. All over the United States and in many foreign countries. It also owned the intellectual property rights in the apple tree, and it was often subject to the piracy of those rights and felt impelled to police and enforce its rights. And that's what I'm going to be dwelling on here. The source of innovation in fruit trees in the United States and elsewhere, including Britain and France and every place else you can think of, historically through the 1920s was mainly from chance finds in the fields. New fruits arose from bud sports and new varieties in the field and orchard. These were then sold by the fortunate farmer to a nursery, which developed and sold the tree. Occasionally, a tasty, attractive apple, for example, appeared in a farmer's orchard. Such innovations were named, preserved, and propagated by grafting. Such sports provided apple eaters in the U.S. with Newton Pippins, Baldwins, Jonathans, and Golden Russets, among other varieties. How did Stark get to use these have these innovations to sell? Well, Stark was never in the business of breeding. It never bred a fruit tree. What it did was, in the late 19th century, begun running an annual fair at which it invited farmers in the region to submit their best fruits. In 1892, the first prize at the Stark Fruit Fair, an annual competition that the firm held to obtain new varieties, went to an apple with a glossy red color that, so the story goes, proprietor Clarence Stark bit into and exclaimed, "Delicious, that will be its name." Stark tracked down the source of the apple, bought sole rights to the tree, which they surrounded with a tall metal fence, and trademarked the fruit as the Stark Delicious Apple. The start was, the source, by the way, was a farmer named Jesse Hyatt in Iowa, and there is, I think, even today, a boulder with a plaque that marks the place that Hyatt found the delicious in his orchard. Oh, here's a kernel. Well, the Stark Brothers still exists. It was sold in '94, but then bought back and made independent again. And the logo for a long time, many decades, was Stark trees bear fruit. So here is, I won't talk about that. Here is the Stark catalog with the red delicious apple in 1899, and it's trademarked. If you could read it more closely, you'd say it says trademark. I'll come back to that point in a minute. Now, all fruit growers, innovators in fruit trees, had a problem in protecting their IP. One problem was that in order to protect any piece of property, you have to specify it. Well, how do you specify an apple or a pear or a peach, say in the 1890s? Maybe you know a little biochemistry. People try to do it by taste, by color, et cetera, et cetera. And what people confronted was that there was basically a huge number of synonyms, and that these had to be somehow regulated. They tried to, the organization was created in the mid-19th century to regulate them, called the American Biotechnological Society. Didn't succeed in that purpose. But also there developed, and this is not directly relevant to our story. Oh, I'm sorry, I have the wrong. All right. What they did was to create a series of chromolithographs of fruits, which were not just for the purposes of art or for the purposes of sales, but for the purposes of identification. And this began in the United States in the 1840s, and it became an industry of botanical illustration for these purposes through the 19th century, the rest of the 19th century, and into the 20th century. So there's one problem is identification, and another problem is that they face theft by competitors. Unlike reapers or electrical light bulbs, plants, of course, reproduce on their own. The ability of an asexually reproducible organism, such as a fruit tree, which could in principle be identically reproduced by grafting, to transmit its desirable characters to succeeding generations, added to the value of its intellectual property, because if you bought the tree, then you know you would get the same tree if you grafted it in your orchard. But that very same ability posed a challenge to the owner of the IP in the fruit tree. Because the fruit trees could be asexually reproduced, and they could be repropagated by cuttings or graftings, then sold on the market by the same or another name. So what you find is that there is a growing clamor among nurserymen, fruit innovators, etc., like Stark Brothers from the 1880s onward for the protection of what we call their intellectual property in their fruits and what they call the rights of originators. The patent system was unavailable to them for a variety of reasons. They just could not patent the living organism in that period. They tried pricing, that didn't work, selling the things for a very high price so you could capture all the downstream revenues that you would lose, but that didn't work very well. They also tried trademarks, and that's why you have Stark Brothers advertising its fruit as trademarked. But these trademarks did not fill the bill. And the reason is trademarking protected only the name. It did little to defend the breeder against the fact that an apple sold by any other name would taste as sweet. In short, trademarking did not protect the breeder's rights in a particular plant or fruit as such, but only his name or reputation. In a few years, any new plant or tree could be anybody's plant or tree. Then, too, there was a legal obstacle established in the 1890s in the United States against the trademarking of a living organism. This was a federal court ruling in district court, I think, in 1895 in a case formerly known as Hoyt et al. Versus J.T. Lovett, commonly known as the Green Mountain Grape case. where the judge declared that it would be legally unjustified to grant a monopoly over, quote, things which are valued more for their natural powers of reproduction and increase than for any other qualities. So, enter the golden delicious apple. The tree originated as a chance new variety on the farm of a man named Mullins in Clay County, West Virginia. In 1914, Paul Stark, one of the Stark brothers, having learned about it, traveled to the farm and bought the tree together with all its propagation rights from Mullins for $5,000. He took cuttings from it and left it standing, but first arranged to have it surrounded by a wire cage to prevent anyone from taking any cuttings and then propagating the tree. After purchase of the tree, Stark Brothers tested it in all parts of the country to see whether it had real commercial value. All this was done at great expense, several $100,000. The golden delicious trees were first put on the market and sold in the spring of 1917 in the United States. And now, of course, I said they're sold in 5 continents, even here in England. So how is Stark Brothers going to protect its apple, the IP in the apple? It was essential to do so, they thought, because 2 or 3 cuttings taken off the original tree or one of its later propagations would be enough to start a good strain of competitive trees. Trademark seemed dicey as a formal protection, though the Stark Brothers did give purchasers the impression that the fruit itself was covered by the mark, not just the name. And lawyers for the Stark Brothers said at one point in the 1920s that our fruit, our golden delicious trees are not patented or trademarked, but people think they are, and let us not disabuse them of the impression. So, how to do it? No patents, trademarks really are non-enforceable. What to do? What they resorted to was a contract. And here is the Stark Golden Delicious contract. Basically what it says to every purchaser at the sign of this, that you could not sell or give away buds, cuttings, or signs of this tree. If you did so, you would be subject to a $100, you would be subject to prosecution, and anybody who turned in a violator of this contract would get a $100 reward, which was not an inconsiderable amount of money in the 1920s. This is a tag that was attached to every single seedling of the golden delicious tree that Stark shipped by the hundreds of thousands. Okay, every single one. On one side is a summary of the agreement. In receiving this tree, you agree that you are fully aware that you have signed, will carry out to the letter the golden delicious purchase agreement, blah, blah, blah. And on the other side, a $100 reward for the arrest and conviction of anyone stealing golden delicious trees, signs, buds, or cuttings and propagating therewith. Okay. Stark, as I say, it sold hundreds of thousands of golden delicious apple trees in every American state and foreign country through the 20s, and it sold it with these tags. After establishing the contract for the golden delicious, Stark Brothers notified every nurseryman on record in the United States by registered mail that it had exclusive control of the golden delicious apple trees. It also placed ads in the leading nursery papers and trade journals calling everyone's attention to our exclusive right to this variety. The ad and the Stark catalog included a warning to be aware, I quote, "We have in our employ a leading national detective agency, and careful investigations are made by them of any alleged infringement of our rights by customers, nurserymen, or anyone else. The agency was the Pinkerton Detective Agency. This is a famous, or you might say infamous, national detective agency, well known for heavy-duty work in strike-breaking in the later 19th century, but also it's an investigative agency, just like any other national investigative agency. In most cases of alleged infringement on Stark's rights to the golden delicious, the firm sent the Pinkertons to investigate the matter. Now, how successful was Stark in enforcing this contract? Well, Stark Stark Brothers believed that the large majority of their customers took the contract seriously and endeavored to live up to its conditions. But violations of their rights did occur for several reasons. Plain ignorance of the contract, the sale of the land with Golden Delicious trees on it, and also willful, knowing defiance of Stark's claims to the intellectual property in the Golden Delicious apple. In the case of ignorance, often the Pinkertons found that the offending nursery did not know of Stark Brothers' rights in the Golden Delicious. On verification of the firm's offense, Stark's lawyer would notify the nursery that it was in violation of Stark's rights and ask that the nursery cease and desist with the implied threat of suit. Usually the offending nursery did so, signing a special contract agreeing not to grow or sell any more Golden Delicious. And Stark had their Pinkerton detectives follow up to see if the nurseryman was living up to the agreement. Where land, including the trees, was bought by someone not made aware of the contract, Stark held that the contract followed the trees, as the Constitution follows the flag, to quote their lawyer. Stark had been able to get all these cases closed up satisfactorily, the lawyer said. Still, the Starks wondered what were the rights of someone who bought the land with Golden Delicious on them, but who had not signed or even known about the contract. Some nurserymen claimed that this gave them the science of Golden Delicious legally. Still, signs were obtained in violation of the contract from purchasers. They might be stolen from orchards of buyers in the dead of night, a means that victimized Stark Brothers itself. But in some important instances, the culprit refused to settle and was defiant. Stark was unable to prevail either through intimidation by the Pinkertons or the threat of lawsuits. Important point, Stark never sued. Why? First of all, there was the specification problem when someone was selling the Golden Delicious under a different name, how to prove that this is the Golden Delicious. Secondly, it would have had to brought suit in any number of multiple legal jurisdictions, and where the juries would be, and the judge might be well sympathetic to the local nurserymen rather than to this behemoth of Stark Brothers based like Monsanto in Missouri. Their price and they might well have lost, because after all this is a private contract, and there were fundamental attitudes towards food. What are you telling me that you have the control over this tree? Doesn't everybody own these trees, etc.? And if they lost, then the contract would be basically nullified everywhere. So they never sued. As a result, they got frustrated with these willful violators, and the Stark Brothers, particularly Paul Stark, was instrumental in establishing, in bringing about the passage of the Plant Patent Act in 1930. It's the first intellectual property protection for living organisms in the world. It laid the foundation for the intellectual property regime essential to Monsanto's success. So let me turn in conclusion, and give me a few more minutes, to come back to Monsanto. Seeded plants were excluded from the Plant Patent Act. The reason was that you could not guarantee that the second generation and succeeding generations would be identical to the first, because as everybody who has children knows, your children are different from the parents in case of sexual reproduction. But then, fast forward to the 1970s and beyond, we get recombinant DNA, which enabled firms like Monsanto in its ag biotech capacity to genetically engineer plants by inserting DNA sequences or whole genes into the plant's genome, and they get transmitted from generation to generation, and so you have a guaranteed transmission between generations of the character that you value the plant for. Secondly, the DNA allows you, or gives you, exquisite specificity. It solves the identification problem. So you have exquisite specificity in the plant, and thus you have an enforceable kind of IP. Then of course there are developments in the legal arena that are relevant here. As Bob Cook-Deegan reminded us this morning, there's Diamond v. Chakrabarty in 1980, which gives authorizes the principle, establishes a principle you can get a utility patent in a living organism. And then in 1985, in the case of ex parte Hibbert, this principle is applied to genetically engineered plants. What about enforceability? Well, since plants are now subject to utility patents, and Monsanto's patents are utility patents, you can then take the matter, at least in the U.S., it becomes a matter in the U.S. of federal law, and the venue is the federal court system, where, check me if this right, the judges are the deciders rather than jury trials, right, in patent cases. Is that correct? Or no? No.
There's
okay.
a jury trial and
all right. So in any case, you have a well-established body of law that's subject to federal law. It's judges and juries, and the chances of success on the part of the company are infinitely greater than in the case of Stark Brothers. So finally, we also have to come back to the resort to aggressive investigation and intimidation by Monsanto. There are really remarkable similarities between the Stark Brothers, the Monsanto and Stark Brothers. Farmers who buy Monsanto's patented Roundup Ready seeds are required to sign an agreement promising not to save the seed produced after each harvest for replanting or to sell the seed to other farmers. This means that farmers must buy new seed every year. This radical departure from age-old practice has created turmoil in the farm country. Some farmers don't fully understand they're not supposed to save Monsanto seeds for next year's planting, which echoes the ignorance of farmers with the Golden Delicious. Others do, but ignore the stipulation rather than throw away a perfectly usable product. Still others say that they don't use Monsanto's genetically modified seeds, but seeds have been blown into their fields by wind or deposited by birds. What we have then is a lot of similarity between, in the tactics, the investigation and intimidation tactics of Stark and Monsanto, which is maybe to say that the Monsanto is not a unique case, but that there are other cases that historically and contemporaneously that we can find that are similar, and maybe this can lead us to exploit history so as to make some policy recommendations, which I will now close with very briefly. What might history teach us here? Well, one thing is that maybe there ought to be a farmer's exemption, whereby the farmer has the right to do whatever he or she pleases with the next generation of seeds after purchasing the purchasing the genetically modified seeds from the originator. Then maybe what we need is some kind of bill of farmers' rights which would protect them in some reasonable way from these really egregious tactics on the part of firms like Monsanto, which are obviously very, very well funded compared with the individual farmer, and protection from harassment and intimidation and the threat of losing everything as a result of their willful or unknowing use of these seeds. And then especially maybe what we need, since we're talking about natural products, is some kind of regulation that protects farmers against suit if they happen to grow seeds unknowingly that blow over into their fields, that is IP protected seeds that blow over into their fields from the fields of other farmers who have knowingly bought them and planted them, etc. So we're in a new ball game here, it seems to me, where history might tell us some things we might think about. Okay.
Thank you.
Wondering if you give much thought to the fact that, as you advocate farmers to be allowed to save and do what they like with.
I'm saying this is something we could really need to think about.
Yeah. Okay. Yeah. But so just wondering whether the issue that if that happens, then industry is likely to use sort of technology rather than the law. So we have hybrids, of course, which you can go back sort of quite a few decades. But also, sort of to technology, as they call it in popular press, technology is to make seeds sterile. And just wondering if, I'm sort of getting what you asked for, not necessarily being, having some consequences that may not necessarily be great, is that if industry can't appropriate in one way through the law, it will do it in other ways through technology.
Well, yeah, I mean, industry has tried that before and done it successfully in the absence of patent protection in the case of hybrid corn.
Yeah.
But so far, to my knowledge, when Funk Brothers sold hybrid corn seed, it was engineered so that the third generation would degenerate, right? So the farmer would then have to come back. But there was no intimidation, there was no harassment, there was no threat of suit, et cetera, as a matter of course in enforcing its intellectual property. So if that's what they want to do and the farmers find it advantageous, okay, but it's something that only those farmers who want to use it will undertake to do. And it seems to me a cleaner way. I'm not trying to say let's get rid of intellectual property in any kind of plans, okay? I'm saying that what we need is an adjustment of the regime that currently exists, which favors the big ones like Monsanto, who are can be ruthless in their right, and give some added weight and leverage to the purchasers and users.
Got a queue building up, Bob and Sigrid.
One thing that would be really useful about this history is to find out if there was any feedback on the Stark brothers that would be relevant to Monsanto in the following sense. If you pursue a business model that pisses off your customers.
That pisses off them.
Do you pay a penalty down the line? So in the long run, Monsanto would learn from Stark that you shouldn't do that because in the long run you're screwing up your stock value or something like that. Is that the story, or is it the story that you can get away with it and make lots of money?
Well, Stark said that most of the violators ceased and desisted once it was called to their attention that they were in violation of the contract. And I think that what this reveals is that there was an ethic in the world of orchardists and nurserymen, that the originators, or at least the developers of new fruit trees and plants, had rights. Okay, you can find this back in the mid-19th century. One of the willful violators was a guy named Schultz, who had a nursery across the river from Stark in Illinois called the Golden Eagle Nursery, and he just sold the Golden Delicious as the Golden Delicious. His lawyers went after him, the Pinkertons, etc. And he said, "It's none of your business where I got the tree, what I'm doing with it." His literature cited, quoted from Hoyt V. Lovett. He was illiterate, but he was very smart. And what Stark did was to bring him up on basically what we would call ethical violations to the American Association of Nurserymen, and they ostracized him. And he just went merrily along doing what he was doing, but the point is that there was an ethic among nurserymen that it was wrong to violate someone's what we call intellectual property in these things. So you have a system of values that needs to be attended to, and people didn't resent, by and large, the Starks. Whereas people do resent Monsanto. So how and why that ethic changed is something else.
Yes, I wanted to thank you for a super interesting talk and totally agree with your policy recommendations. I thought you might be interested to know that currently in Europe, as you say, this is about natural products, but it's also about processes. It's also about essentially biological processes of breeding and selection. And in Europe, there's currently a big controversy over, it's been going on for a while, but as you know, essentially biological processes are supposed to be excluded from patentability in Europe.
Yeah.
And yet the EPO grants patents on things that are completely essentially biological processes, pure breeding and selection, and the only intervention by man is, for instance, in a case, a patent granted to the Ministry of Agriculture of Israel. You inspect the tomato on the vine and you just watch whether the skin looks a bit crinkled. That's an intervention by man. That's enough in Europe to get you a patent. And these things are currently, they're going to come before the highest instance, and the oral hearings, which are accessible to the public, are later this month on the 19th and the 20th of July.
Is that before the European Patent Office in Munich?
Yes, that's before the enlarged Court of Appeal of the European Patent Office.
Well, I mean, I think that what you say is extremely interesting, and the granting of patents on basically breeding by natural processes is remarkable. There is another regime, IP protection regime, called the Plant Variety Protection Act in the United States, or UPOV internationally, that try to allow for that. But that includes a research exemption, and at least in this country, I mean in the US, a research exemption and a farmer's exemption. Okay, so it's much more traditional and pays attention to the need of farmers to do this, whereas the utility patent regime is far more threatening. Okay, and it'll be interesting to see what happens with that. But with regard to the granting of utility patents on natural, essentially biological processes, it seems to me that it's another example of the trend that I was trying to articulate in response to Mario's wonderful talk yesterday, and that is that there has been a movement grounded in a zealous eagerness to promote in innovation, entrepreneurship, economic development, and so on, in the intellectual property regime, certainly of the West, in the United States, England, and continental Europe, to grant intellectual property rights over excessively, okay, over things that maybe should not have the same kind of intellectual property rights that we associate with the patents for widgets.
Christine, did you have?
I have a question. I was wondering if perhaps maybe in the Monsanto case, things are worse perhaps than in the Stark case, because it would be, well, it's easier for farmers to know about the Monsanto case, and yet if the pollen blows over their land, if they're surrounded by people planting Monsanto, how easy is it going to be for them to not violate Monsanto's intellectual property rights?
Very difficult. Very difficult. I mean, the comparable case, you're right, there's a distinct difference here. One is seeded plants where pollen can blow over. The other is trees, which don't blow over. But nevertheless, people can buy the land without knowledge of the contract with the trees growing on it, or just be ignorant of the contract, or have forgotten about it, So it is a big difference. My wife said to me yesterday, I was telling her, our host in Harrogate, where we were staying, about this, that why don't the farmers who are beleaguered by Monsanto go after their neighbors who allow their seeds, their pollen, to blow over? See, they're not protecting their neighbors' fields. And I think that's another interesting point, probably an area, Becky, you can say something about it, an area of possible new litigation in this regard. I don't know.
So I'm interested in the ideas that you were discussing of putting contracts in place to sort of control how one uses the intellectual property that you purchase. And there must be a massive benefit that farmers sort of enjoy to overcome what would otherwise be a barrier to them participating in a contract with Monsanto. Sort of
well,
very distasteful things come under the threat of surveillance and all the rest. And you've got to have a very big economic driver to sort of make
those that will willingly enter into the purchase of the seeds from Monsanto. Is that what you mean?
But my question moves on from that, because actually in science we do very often enjoy a product which comes under license to us, and the intellectual enhancement of that product that we might make ourselves, actually the license says we don't own. And that's quite an insidious sort of position to find yourself in.
I'm
So
not sure I
GFP
understand
is
the
example I'm
question.
thinking about. So in the research biotech world, a lot of work is running on this green fluorescent protein, which is a patented material from California again. You know, sort of, and actually, if you, as an experimentalist, do something to GFP to make it better, you find you are actually not the owner of that new improvement because it's subject to the license that ordinary use of that material sort of keeps you under.
Well, I agree. I think if I understand correctly what you're saying, but these people, I mean the farmers, do believe that who buy Monsanto seeds, Roundup Ready seeds, they believe that they will derive an economic benefit from doing so. But then, and they're willing, to abide by the contract of no seed saving, et cetera, as I said. So it's only those who are not buying them, right? Or who are saving the seed and not knowing they're not supposed to save the seed, et cetera. Which is why maybe we need to. I'm not sure I understand the question. I'm sorry.
So maybe we'll carry this one on over the coffee, which is coming in a moment. But before we get there, I've got one question myself.
By the way, here is Mr. Schultz's advertisement. Golden University.
So Dan, at the end of your talk, you boldly contradicted Mario's proclamation yesterday, which is that there are no lessons from history. I wonder, though, what you would say to someone who said, great history but wrong lessons. Surely the lesson from your story is that aggressive protection of intellectual property makes for success. Stark Brothers still around. So isn't the lesson for Monsanto that the more aggressive you are in pursuing your property rights, the better off you'll be as a firm?
Well, you might have said that about U.S. Steel in 1900, but we got antitrust laws that sought to restrain bigness in business. That was not necessarily cutthroat, but could be cutthroat. And it seems to me that we're better off in the United States as a country and here in Europe for government regulation of property rights in ways that balance the interests of the owners of the property rights with the users of the property rights in ways that are equitable. Otherwise, it seems to me that you will have a kind of oligarchic, ruthless, uncompromising control of, in this case, the world's food supply. That's a gross extrapolation, but you can imagine it's moving in that direction if you allow the Monsantos of the world just to proceed in a completely untrammeled way. And I don't think that's good for an equitable democratic society. That's all.
Well, I believe there is GM-free coffee and answers. But before we go, I just want to let you know we're starting again at 11:30, and please join me in thanking Dan for